Hello everyone, welcome back. This is S.C. Coleman, author, and in this video we're going to be talking about law, or more accurately, laws. Now most people only know the context of the so-called the law. Not which law, what law, but the law, as though there were only one. There is, however, not only one law, and there's specifically not only one type of law either. I would say the majority of people do not know any different. Attorneys among each other might ask them among themselves, which law do you practice? Right? And then you've got stuff like estate law, part of probate, so-called. You have trust law, criminal, traffic, that type of thing. However, that is all within context or under the umbrella of one type of law. Currently what we have today is called equitable law. We have courts of equity. Equity is specifically based out of the balance of value, and it is administered based on corporate and mercantile ideas or concepts. This is the reason why you have no solicitation signs and no trespassing. Trespass is a term that gives you the right to sue if, say, you're a farmer and another farmer's cow comes onto your property and breaks your fence. That's a trespass and only gives you the right to sue. But what we have right now is somewhat of a mixture where things being controlled by courts of equity are administered into and sort of bleed into other types of law. These courts of equity that we have today all use the symbol of the scales. The scale is used by merchants to weigh products so that if you're doing a trade between rice and eggs, you ensure you have the same weight. That's what the purpose of these scales are. And the reason why the court system today, the so-called court system today, has scales is because they are courts of equity. They only determine things in the aspects of value, valuation. It all has to do with whether or not something has within it equitable value or equity. So basically, if you think about that, not in the context of current systems, but rather in the way an equitable system would work, an equitable law system would work, essentially, it's like the weights and measures. Equitable law would be 10 eggs is equal to 1 bag of rice. That's equity, that's equitable law. And when you have people who implement schemes to swindle their customers, say you have you have a customer and you have a baker, right? And consistently the baker is selling a worse product, below its weight, and doing a whole bunch of other stuff like that. Or you have somebody who sells milk, and then over time the milk basically becomes so diluted that they're only just selling water at some point. That is a breach of equitable law. Mostly that only gives you the ability to sue for damages. Hence the word suing for damages. So the idea of equitable law is mostly what people refer to as the law. Just about everything today is administered under courts of equity. And when somebody goes around and says you have to obey the law, you have to follow the law, you have to do what the law says, or it's the law, right? You know, do this, it's the law. Right? When somebody says that phrase, they are generally going to be talking about matters of equity. because just about everything, as far as going and hiring an attorney, and then going to this place where you've got a presiding judge who wears his robes and talks down to you on all that stuff, that's a court of equity. That's what you're talking about today. Interestingly, churches are courts of equity as well. The so-called universal church, where they weigh things based off of the value of somebody's life and their social position and things like that, right? The idea of determining somebody's value based off of their quote-unquote net worth or how much of something they have, that is a method of valuation for equitable reasons. When you go to a church, the determination on whether or not you are a vagabond or you're a missionary or you're a priest or you're a bishop or you're the pope or any of that stuff, that all is a societal determination of your value. So these are some things to keep in mind. The next type we're going to look at is martial or military law, and is essentially based out of force alone. It is who has superior force. Now it comes into many structures. You have the organization of troops and the ability to maneuver organized elements in a force mechanism, usually issued by decree of a commander or so forth. In the military, you might get a warning order from a general or colonel, a theater commander, whatnot, and then you'll have mission parameters, what your purpose is there, and then below that you might have very specific orders delineated by field commanders and things like that. But either way, what you're talking about here is a command structure, and the mechanism is administered through force. Now, when you're talking about the courts of equity today and how they bleed into others, one of the biggest ones here is martial or military law. Right now today, we in fact have a mixture of courts of equity administering martial or military law. The reason why you are forced, and this is why I'm using the word force, the reason why you are forced to follow equitable courts is because their force mechanism is what they call law enforcement. Police, sheriffs, highway patrol, traffic security, health security, humane society people, parks rangers, all of that stuff. All of the people who carry around some intimidating appearance and carry a gun. And then they go and tell you to do something, or they give you a fine, they tell you you need a license, they give you some type of paperwork. They are the military force mechanism for the equitable courts, and everything they do is administered based off of concepts of equity. Another concept, though, for the military force and martial force idea is a local community gets together, and the people who have and can wear and bear arms go around and ensure that everything is followed based off of their community parameters. There are many different styles and forms of this. You of course have the occupation forces concept, where you have a military who comes in and then holds an area and basically tells the population to do this or else. Interestingly, we have a mixture of that as well, where you have all of these hidden hand foreign investors who are operating these courts of equity and making everything to be based off of valuations that they choose, right? They set the valuations. They declare the price for gasoline is this, and the price for eggs over here is this or that, or the price for butter. They declare across the board, and people who don't want to go along with it are either driven out for underselling or for price gouging. So that's the way it is today. And those courts of equity, the judges in those courts of equity issue their edicts and decrees to the force mechanism, the so-called law enforcement, so that they can go and send their uniformed thugs to people's houses to tell those people what to do. And this is being done on behalf of, in many cases, foreign hidden investors. And therefore you have the occupation mechanism at play. You have a foreign occupation being enforced against you. Just because you have local people wearing that uniform, or maybe local, going around kicking down doors and yelling at people and pulling them over on the side of the road with sirens and lights and all this nonsense, it doesn't make them any less of a foreign occupier because they are acting on behalf of distant investors. The next element that we're going to talk about as far as the main types of laws here is conciliatory. Conciliatory law is the idea of a council. It's a group of people which unify to decide on various things, what they're going to do, how they're going to approach stuff. Usually councils do not get together and do not live together constantly and do not administer stuff. With these courts of equity, you usually have a judge who's basically always there or whatnot, or gets called in or whatever. With the military law, you usually have somebody who stands on watch, a watch commander. You've usually got somebody there who's always ready to go. With councils, it's not the case. Usually a council has a very specific time that they will meet and whatnot. In some cases, you can have a council convened at any notice at any time. And in fact, you can have standing councils sometimes where they are there always, constantly. So that just all depends on how it is. Most of us are familiar with the council law system in courts, but it's not administered in that way. We don't call them that, essentially. But they're still active today when you have a board, so-called, of some company or whatever who gets together and they decide on how the company is going to go. And then maybe you have a hearing board deciding on whether or not somebody's going to be fired. That is in fact a court. They have convened a court. They're just not calling it that. They're calling it the hearing board for disciplinary conduct or something, right? They call it other things, but that's still a court. There are very few courts today which are not done under the equity system, because even in that example where I said you have a board that gets together at some corporation to decide whether or not they're going to fire their CEO, that's still probably going to be done based off of equity, the valuation of the individual, what they bring to the company, that sort of thing. It's not exactly a very natural or good way to run things. You know, a company might fire somebody who's very good for the company, but on paper does not look like they're good for the company. They don't bring in profits. They don't have high profit margins, right? And they might not be very good at managing the books and all that stuff. But they keep the ship running. They keep morale high. The people at the company do it well. And they might fire that person and put somebody who looks good on paper in that position, and because they did that, the company goes under and they don't turn a profit and the whole thing collapses, right? Because everybody at the company hates this person and it just causes a major disruption and all that. So just doing things based solely off of the equitable value, the numbers as it were, that's not a good way for any of us to live, and we see the consequences of that today. There is no peace. There's constant chaos. Everybody lives under oppression. It's not a good way to live. So, and one of the keys to that is, I believe, the main reason why the equitable system is so disproportionate is because it's also mixed with the martial. The entire globe has been under martial or military law for a long time, just called law enforcement. And that's it. The people who go around with guns threatening you, telling you what to do, they are instituting military martial law based off of force alone. They are just practicing it and putting it in place on behalf of the equity. But the fact is that equity court system wouldn't be able to do what it's doing if it didn't have the force mechanism to go around and threaten people into submission. So that's the big difference there. You take away that force mechanism from the equity courts, and they won't be as obtrusive, obnoxious, and disproportionate as they are currently. Of course, that's easier said than done. The next one is contract law. It is based off of agreements. It's where two or more people mutually agree on how to proceed. This is usually still framed in context to the courts of equity. But when you have a contract signed between one or more parties, and the people who signed that contract get together and determine whether or not the contract was breached or whatnot, in fact, you have what's similar to a council, but it's still going to be based off that contract. And in this context, we can call that contract law. Now, if you take away the court of equity and say they don't exist, everybody ignores them, they're garbage, they're a waste of time. And I mean all the courts of equity, all the criminal courts, all the judicial courts, all the Supreme Court, the probate court, all of them. They're all courts of equity. They are all meaningless in this context. Because the only thing that matters when it comes to a contract are the people who signed it. The people who sit down and decide what they're going to do. Either a man and wife who signed a marriage contract, or you have a couple cattle ranchers who signed a contract about a land lease for where they can go and where their cattle can go and feed. The only thing that matters in that context are the people who signed that contract, and they sit down and decide how to do what they're going to do. They don't. In many cases, they don't even want anyone outside of that sphere of influence even involved in it. And in there, they can argue things based off of what was written in the contract, or if they want to amend the contract, or they want to change stuff, and all that nonsense. Right? So that's how contract law actually works. It is a practical speaking element. It doesn't involve attorneys or some crap that you see on TV or any of that stuff. It involves only the people who signed that document among themselves. And if somebody breaches that contract, it is the other signatories to that contract who will hold that individual accountable, not necessarily in the courts of equity. There will be repercussions to that person. Even if it's a man and wife who signed a marriage contract and the man, cheats on the wife, and then the wife goes and keys his car or does something like that, as a retaliatory measure based off of a breach of contract. So that's something that needs to be understood. We really need to get out of this mindset of only thinking about law in the narrowly focused space of what is of equitable value. It's quite ridiculous. Now the last one, and by far not the only, these are not the only types of laws out there, or law systems. Declaratory is a big one. It is usually written or spoken, and it will come in the form of a decree. Usually, I would say the equitable courts of today do not actually decree things. There's simple signage that gets put up, or there's according to this or that, or according to so-and-so. You find things that say stuff like by order of the safety service director and whatnot. And when a judge issues a warrant, it's probably going to be some type of standard format letter with a stamp on it, or maybe it'll be written up by a secretary or whatnot. But either way, those aren't really decrees. This is not exactly what I'm talking about. The way you can think about it is a king. A king writes a law in which the king states this is how things are going to go. The Merchants Guild in 17th century France, the Ancien regime or the old regime, whichever one you want, will declare the rights and privileges of the Merchants Guild for, say, the city of Paris, the Ville de Paris or Faubourg. There, in those articles of decree, right, the king is decreeing it, that is enough for them to go to the king's men to enforce it, to go to the men of the sword or anyone in the area who submit to the king. And then you might have individuals in the area who decide to ignore it, and thus you have rebellion against the crown, right? So that's how that works, how that mechanism works. So a decree is kind of like you going out there and saying, this is the way it's going to be. The judges who issue warrants aren't decreeing things. What they're doing is they're simply filling out a form based off of a certain mechanism because you violated something in their equitable system, which entirely has to do with the valuation of things. And then they submit that filled out form to a enforcement mechanism of military force for the execution of equitable rules. That's not really what we're talking about with the decree. But that's still how people will probably think about it. If you talk about decree-based law, they're going to say, oh, is that just like what judge goes up there and decrees something? No, that's not what it is. It could be, but it's probably not. Because in general, they are bound by their equitable system. It's not right, and it's certainly illegitimate and unlawful in most cases, but either way, that's the way it is. So with the decree, it's not really about a commander issuing orders either, because that's all based around the idea of a law by force. This is sort of law of legitimacy, what you recognize as legitimate, being a emperor or a king or whatnot. Somebody goes out there and everybody in the area listens to them and follows what they say, and then that person goes out and declares things. That is declaratory law. In some cases, you have a system where laws in the declaratory are made on paper. And in those systems, often, if you don't believe the paper to be legitimate, meaning a pretender or somebody else is doing it in the name of that person, you can demand that that individual present themselves and declare what they're saying in person. So that's how a lot of declaratory systems were, and there's an example of this with Karl von Clausewitz, who said he would put down his arms if the king personally went to him and told him to do so. And this is because he knew that the orders that were being sent to him to stand down on paper and scrolls with, even though it bore the king's seal and everything, was not actually coming from the king, and so therefore the king would not actually present himself because the king was in fact not there. And that is the case in many historical examples, where you have a king who is either captured or their seal has been stolen, and there's somebody who's doing things based out of their name, but is not actually them, and then somebody comes along and says, this is fraudulent, I want to see the person in the flesh, right? So there's a lot of checks like that. In the U.S. Constitution and many other constitutional documents, these are not contract law, these are not equitable law, they're not martial law, and they're not declaratory. They are, in fact, a mixture. Within the U.S. Constitution, you have military law under the militia mechanism, being anyone who can keep and bear arms. Basically meaning you go around and summon your neighbors who have weapons and all get together and force the adherence to the law, being the U.S. Constitution. Of course, you also have the naval and land forces. Therefore, your force mechanism. The second that you have is the conciliatory law, which is the unification of representatives and various things like that. The president is technically not part of that. The president is part of the military martial capacity. The equitable sense in the Constitution has to do with the weights and measures, standards of weights and measures, which is supposed to be set by Congress. So the council law sets the equitable law. That is the equity is the standards of weights and measures. It's also the imprinting of money, the minting of money, all of that stuff. That has to do with equitable law. The Congress is supposed to set the equitable law, not the way we have it today. The president sets the martial law, and the conciliatory law, of course, is based out of the Congress, and then Congress is the only one that can intervene in contracts, and there you have the contract law listed about the intervention into contracts, and then naturally you also have declaratory. Declaratory is probably the one that I'm not fully certain about its inclusion in the Constitution, because as I'm aware of, there is no specific mechanism to challenge someone to appear in the flesh to show that their declarations are being in fact made by them. There can of course be declarations made by the various mechanisms that are in the Constitution itself. And there's many other aspects to be contemplated Either way, I would stipulate that those are the main areas of law. And one of the reasons why it's so important to understand this is so that you don't look at things only in the terms of the narrowly licensed adjudication of law or adjudication of law by attorneys of equitable courts. If you think only in terms of that, then you will never be able to succeed in the real world. Licensed attorneys are trained in a very narrow sphere of thought and capability. Outside of that protected safe space of their court system, they can't function. You can dismantle easily any licensed attorney if you step outside of the courts and to target them in every capacity of all of these other law systems, even in equitable, because they actually don't understand equity law. All they understand is their sphere, their area that they operate in, based off of judges' decisions and things like that. They can't operate outside of that. They don't know how to, and when somebody goes after them and attacks them outside of these systems, they are absolutely defeated. You go after them personally, financially, go after their families, the people they're associated with. You go after them in a capacity that exists within the real world. They won't know how to do it. All they'll be able to do is file decrees and reports and other nonsense inside of their little closed structure sphere. They don't know how to deal with that. The idea of the court of common opinion is another type of idea, but that is essentially speaking part of the conciliatory aspect, where the court of public opinion is that people get together in the public just out of a generally shared perspective towards something. So when you understand these different types, you can approach things and solve problems in the real world and not constantly be going and asking for permission and safety and recompense from this singular entity which has a very limited capacity. The court system today, with their law enforcement mechanism, has a very limited capacity. The police, the sheriffs, the highway patrol, the state forces, all of them, they don't have that much that they can actually do. And in many cases, they won't fix problems for people. And they'll just say stuff like, oh, you're out of luck. It's just, it's just not your day. You can't do it. That's not true. You have to understand how to manage and to approach these systems and how to conduct yourself within these other spheres. There might not be declaratory courts, the king's court, as it were. Might not be contract courts, courts-based systems based on the intervention of contracts. There might not be conciliatory courts where you can go to some council here and there and talk about stuff, and might not be a marshal or military head commander that you can go and talk to have them administer law. And the equitable courts are not going to be on your side either. They're not going to value your input or who you are based off of your standing. They're going to look at you as a commodity. They're not going to look at you as somebody who can go to that court and have standing and argue about stuff, because the only people who have standing in those courts are licensed attorneys, basically. So you don't really have any court systems that you can go to, but this doesn't mean that you cannot operate based off of those fundamental concepts and aspects of law. That doesn't mean that you can't understand the force mechanism of law. Force makes right. It doesn't matter what badge you wear, what uniform you wear. Superior force will always reign. Force majeure is everything is just about always reduced to force. And whoever is superior force is the one who is right. Might makes right. That saying, right? If somebody comes to your house and they're wearing a uniform and they get shot in the face, and then all their friends come and they all die, no one else is going to try that. Meaning you won, you're victorious, your law stands. That is the idea of force of martial law, military law, law by force. With these other ones, the council law, well, that would be, you get together with a group of your neighbors and you talk about how you're going to deal with stuff. Now you're in conciliatory law. You write up a contract and you agree to do specific things based off that contract. Now you've got contract law. And then, based off of that contract, you go around and start declaring things. Now you've got declaratory law. That's how this works. Those are just simple examples about how you step outside of the narrowly defined and controlled sphere of the equitable courts that we have today, and you actually start practicing law in the real world where you don't need a license, and it doesn't matter what anyone says or argues or whines and complains about, because at the end of the day, it is the individual who administers the law by force, whatever that might mean, financial, public opinion. It doesn't always have to be physical, but either way, forces adherence to it one way or the other. And that's how law is concerned. There always has to be some type of way to force it, because there will be those who don't want to follow it, who don't want to believe it, and to laugh at your face and don't believe that it's true. And right now we have a major conflict going on around these types of laws between different groups and whatnot. And a lot of that conflict, honestly, I believe is inevitable, but it's not necessarily a bad thing. It opens up the door for a lot of these old aspects of law and legitimate governance to be re-emplaced.